24-7276 and 24-7377. Each side will have 25 minutes, but I know we have a division of time.
Good morning, Your Honors, and may it please the Court. Jacob Ecker for the federal government. This Court should dismiss the Center's appeal for lack of jurisdiction. The Court's decision in Alsea Valley is on all fours and dictates that the District Court's remand order is not final for purposes of appellate jurisdiction. The case below involved the National Marine Fisheries Service designation of critical habitat for 2 Arctic seal species. The District Court held that the agency failed to consider certain factors relating to the size and location of the designation, and the District Court remanded to the agency for further proceedings. The agency initially appealed, but voluntarily dismissed that appeal and accepted the Court's remand order. Without the agency's participation, the District Court's remand order is not final under Alsea Valley. The principal reason...
Go ahead. I have a question about how to read the District Court's remand order. So it seems possible to read it as actually precluding the service from designating the same territory again on remand. The sentence that where the court says that it did not read the ESA to permit the service to designate nearly all of the seals' occupied habitat within the United States as indispensable to the seals' conservation. Is that sentence saying that the same designation cannot be done on remand?
I don't read the District Court's remand order that way. The way I think the government has read it is that it's a general remand like those in Alsea Valley and in your 2023 decision in CBD, where the agency can potentially reach the same outcome on remand. It may or may not, but the point of those cases and the remand here is that the decision need not come to this court until the agency's remand proceedings have concluded.
So how do we said in, I guess I want to make sure that the government is taking the same position here that I read your briefs, because I have the same issue Judge Friedland has. It seems to me that jurisdiction will depend on the scope of and the reading of the District Court's order. So in your briefs, you said that it's still possible to designate the same areas as critical habitat, and you said that there would still be this possibility of the same result, but taking into account the factors identified. So is that the government's position today?
Yes, Your Honor. And you'll see that we maintained that position in our third brief after we dismissed our appeal. So that we maintain that position today, which is that the District Court's remand order is the type of general remand order like in Alsea Valley and its progeny.
And so does the fact that you're saying that affect how we should read this? I mean, if we wouldn't have read it that way, what's the implication of you saying this today?
That's a fair question, Your Honor. I think the court is entitled to read the District Court's opinion, in the way that it deems fit. Our view is that the District Court's remand order is a general one. And so, I think the point that the government makes at this point is that order has placed the decision-making process back before the agency. So the agency is going to parse that decision in the first instance. If this court disagrees with how the agency views the District Court's remand order, it would have the opportunity following a subsequent challenge and a subsequent appeal to pass on that.
But if the District Court has taken off the table doing the same thing again, then we're kind of in a similar situation to Crow, aren't we?
I'm not sure that's right, because in Alsea Valley itself, the District Court had taken off the table one possible outcome, which in that case, the agency had listed only naturally spawning coho salmon and not hatchery-spawned salmon. And the District Court, as this court's opinion explained, had sort of cordoned off and put a border around that outcome.
I mean, it was, as I read it, it was more of they'd cordoned off a possible rationale for a decision, but not exactly an outcome, because it was more just like you need to be consistent, then you can't do this.
I think, Your Honor, if the court reads the District Court's remand order in the way that you're suggesting, it does bring it closer to cases like Crow than Alsea, not closer than it would be under our reading of the District Court's remand order. I'm not sure that there's a case that squarely addresses this exact situation. So under that reading. Now, we dispute that reading, and so we maintain that the remand order is a general one. If the court disagrees, I think Alsea Valley ought to still apply because there's a broad range of outcomes that remain possible on remand.
That's a little bit different than Crow, as I understand it, because there was essentially ordering the Fish and Wildlife Service to include something in its final order, which is a little bit different here.
That's right. So the Crow, I think, it's about this idea that there's really nothing left for the agency to do on that specific issue, right? The district court's remand order required that the ultimate rule include this recalibration facet of it, and that was, like other cases where there's really nothing left for the agency to do on remand, and so as a practical matter, it's final. And here,
It's hard to figure out what Crow was doing, though, because it seems like that could have been appealed later, and so I don't know, do you have an explanation of what we should make of Crow and the fact that that could have been appealed later?
It's fair enough. I mean, it's a fair question. I think there is some tension in the court's case law. I think your 2023 decision addresses that aptly, and I don't think the court should depart from the reasoning in the 2023 CBD decision here.
I just wanted on the question of how to read the district court's order. I understand the principal brief by the NMFS. There's at page 28 to 29, seemingly at intention with your current read. So that also just highlights, I guess, maybe that the district court order is susceptible to more than one reading. But here it says the court repeatedly referred to the 160 million acre size of the designations in the course of concluding that the court does not read the ESA to permit the service to designate nearly all of its seals occupied habitat, and goes on to argue all the reasons why that was wrong. And there's no sound basis for the district court to manufacture an additional prohibition against designating nearly all of a species occupied habitat, which seems to me as that at least the original read was that the district court did in fact prohibit designation of nearly all of a species occupied habitat.
I certainly understand what you're saying, Judge Sung. I think we read the remand order as more general than at least the Crow Indian Tribe remand, because it's not directing a particular outcome. In that case, part of the remand required an aspect of the rule be included. And here, regardless of the rationale, which our opening brief, which is no longer before the court attacked, I mean, that is not part of the remand order. It's part of the rationale that the agency is going to have to grapple with on remand. And so the government's view is that this case is closer to Alsea Valley, Pitt River, and the 2023 CBD decision than it is to Crow and cases like it. And so we urge the court to dismiss for lack of...
Sorry, can I go back to this question of whether there's some sort of estoppel or something from what you're saying today? How do we know that on remand the agency would read this the way you're saying today?
I can't provide a guarantee on that front, right? And I think that's part of why Alsea Valley supports dismissal, because I can't predict the agency's outcome at this point, and it may mean that these proceedings are unnecessary, or it may mean that a later appeal is the proper time for that to get adjudicated.
So your position is on remand, the agency can say that it had no leeway, that it had to, or it must issue in a certain manner. That really doesn't seem right to me that you can stand here and make representation as you have under part of the agency, and then the agency would be able to flip that.
The government's position today is that that's not what the remand order says. I can't control the outcome before the agency, but my read...
No, but I mean,
can
the service go back and say, you must do this?
Or you cannot?
You cannot, or you must. You cannot do this. You cannot designate nearly all of the seal's habitat.
I understand the court's concern, and it comes from that language that Judge Sung quoted. I just can't get ahead of the agency's process at this point, and I'm
So nothing.
know that's
you're-
unsatisfying,
What
I
you're
understand.
saying today isn't binding on the agency on remand.
I don't think so.
And how long do you think this will take?
Yeah, that was my.
Do not know. I know they've started thinking about what a remand would look like. Given this appeal and the forceful arguments that the center has made for jurisdiction, they've not yet gotten very far in that process because they want to see how this appeal plays
Because
out.
we're in a situation, right, where last time they needed to have a court order to actually do this. I mean, will this never happen?
I don't know the answer. I know that if there is substantial delay, that there are rights of action that can accrue from that context. You're right to point to that, Judge Friedland. The center has sued in the past seeking designations, and the ESA provides for that.
Is that another distinction between this case and ALSI, where, if I remember correctly, the agency at the time we were considering the case and whether we had jurisdiction, the agency had already sort of presented a plan about what it was going to do and engaging in new consideration of the rules that did seem to think that these other options for reaching the same outcome were actually viable and potentially going to happen as a practical matter?
That's true. The court did point to that in ALSI. I'm not sure that those same dynamics were at play in CBD or Crow. I'm just not recalling on the top of my head. But
Do you think if your position is correct, would we also lack jurisdiction over Alaska's cross appeal?
well, so Alaska, I think you could certainly dismiss that cross appeal as well. They've committed to voluntarily dismiss that appeal. And we haven't taken a position on Alsea Valley, but I certainly understand extending the logic to that appeal as well.
I guess we can ask them about that.
Right.
Thank you, Your Honors.
Okay, thank you. So, who's next?
Good morning, Your Honors, and may it please the Court, Kristen Monsell on behalf of Center for Biological Diversity Appellants Cross Appellees. I'd like to reserve 5 minutes of my time for rebuttal. And before addressing the merits, I'd like to address why this court has jurisdiction to hear this appeal. And that's because this case falls squarely within the exceptions articulated by this court in Alsea Valley. And to comply with the district court's order on remand, the agency must apply entirely new substantive factors that the district court invented, such that it won't be the same decision on remand. It will be based on entirely new substantive considerations mandated by the district court.
So I know you argued this in your brief too, but I have trouble understanding. It seems like you're basically saying the procedures the agency will follow, the things the agency will need to consider are wrong things. But if the agency could get to the same outcome about what is designated, I'm not sure why those procedures or considerations are really of interest to you. You really care about the outcome, right? Like, why do you care if the agency thinks about a few extra things?
It's true that we care about the ultimate outcome, but the agency in its original merits brief said, and I quote on page 222, that the court went so far as to state its interpretation sufficiently broadly as to appear to foreclose the agency's designations for the seals altogether.
Okay, that's a different argument, though. That's the outcome can't be the same, and that's not about sort of the procedures along the way. So I guess I personally think that's the much stronger argument than something about what has to be considered along the way.
Yeah, I think both are true here. The constrictions that the district court put on the agency's remand mean that it essentially cannot issue the same decision, both legally and practically. And it's the legal aspect of it that I think maybe is the more specific answer to your question, Your Honor, that the agency now has to apply this new substantive framework that does not exist in the statute and that elevates the bar for critical habitat designations. And that's why we think this case is sort of on point with the Crow Indian tribe case. There, the district court's decision foreclosed any relief to the interveners on the issue of whether a future delisting rule had to include recalibration because the district court ordered that it did. And that's the same situation we have here. The district court orders means that a future critical habitat designation must apply the standard for an unoccupied critical habitat in designating occupied critical habitat, which this court has repeatedly recognized is a much more onerous standard, must evaluate foreign conservation efforts, and must consider excluding the areas Alaska wanted out. And this appeal is the only way that we can get those issues heard, because the legal questions are distinct from whether the ESA mandates that the agency do certain things versus whether it's
let me just, it seems to me there's sort of a question of you could win the battle here and lose the war, in that, we could have jurisdiction, and if we disagree with you on the merits, then you would never have the opportunity to go back as you might on a remand. And so I guess your position is jurisdiction and decide based on this record. Is that your position?
Yes, that's correct, Your Honor. We think the district court was wrong and elevates the bar for critical habitat designations in a manner that is inconsistent with the plain language of the statute.
So can I go back to what you think would happen on remand? So if on remand the agency did these procedures, came up with a narrower designation of territory, why couldn't you appeal then and say, this is too narrow and it's because of these three interpretations that are wrong, and appeal then, later, in 5 years or 10 years or whatever long time it would be, to say these same things you're saying now?
I think the distinction is that the legal question that the court would be addressing at that point would be different than it is addressing now. I think there's a...
In what way, though? Because it would, if the agency uses these same three principles that you think are wrong, why would it be different later? You'd still be saying they should not have relied on those.
Because the district court's order, it is based on its interpretation of the plain language of the Endangered Species Act and what the agency must do in designating critical habitat, not just for these seals, but for any species. And so it has repercussions outside of this case as well. However, if the agency does consider these, three factors, and we ultimately decide to challenge that decision, I think the question the court will be posed with at that point whether it was an abuse of discretion for the agency to have considered those factors, not this plain language of the ESA argument that we have.
Well, why wouldn't that be preserved? I mean, why wouldn't that be part of the package, I think, is what we're trying to get at, that would be appealed from the agency's decision is not just going to be these factors. I mean, it's going to make... Basically, it's going to have to incorporate in its decision a number of these other statutory interpretations. So wouldn't the whole package come back up?
Well, again, I would point the court to the Crow Indian tribe case where this court held it had jurisdiction over an issue because the district court's remand order constrained the agency's discretion in such a way that it had to include this recalibration issue in any future delisting rule. So even though interveners in that case could have ultimately gotten what they wanted, which was the delisting of the grizzly bear, that could only occur if the agency did this specific substantive aspect of its rulemaking. And that's the same situation that we have here. The district court has imposed substantive obligations on the agency that don't exist.
So as I read Crow, though, Crow treated that recalibration as sort of an end in itself. I admit I don't really understand that because it seems more like a procedure along the way to a decision, but that wasn't treated that way. It was like including this thing is kind of the end of itself. And you're talking more about the procedures along the way to the end in itself, as I understand your argument. It's like what's going to get considered when you get to the designation.
Yes. However, I would also note that as this court said in Pitt River and other cases, the Alsea Valley didn't create a hard and fast rule against an appeal in this situation, and that the exceptions are considerations rather than strict prerequisites. So I think that the court can look at the exceptions through a practicality lens. And here, I think it makes sense that these purely legal issues of statutory construction be considered now rather than waiting the uncertain outcome of some protracted remand based on what, we think are clearly erroneous legal premises.
That kind of begs the question. I mean, that might be your preference to get those statutory determinations settled now, but that doesn't say what we originally asked is, isn't the whole package going to come back up if you disagree with the ultimate direction that the service goes?
Yes, it
would come back up.
It could.
It's just you'd prefer it now, not later.
Well, I think it also makes judicial sense in the interest of judicial efficiency, which I think is the whole premise underlying the Alsea Valley line of cases. And I think if it does look the same, then Alaska is going to sue. And if it doesn't look the same, then we might. So it makes more sense to just consider these fundamental issues now that, again, have repercussions, not just for these seals that are now deprived of these protections, but many other species for their critical habitat designations.
Sorry, can I just, now it seems like maybe you're kind of taking the premise that it actually could be appealed later, and I just wanted to follow up to make sure I understand your position. So it seems like if the agency on remand felt bound by these statutory interpretations that you think are wrong, it would probably say that, and so then there could be a later appeal where we would have to figure out these statutory interpretation questions. But your earlier position was that somehow that wouldn't happen, and could you just explain why?
I think there's a legal aspect of this and then a practical aspect of this, and I think practically speaking, it's very unlikely we would see the same rule on remand because of the constrictions the district court put on the agency and because of what the agency has already said about how it's interpreting the district court remand to essentially preclude these designations. So
wait a second, where are you thinking they're saying that? Because they just told us they're not saying that.
Well, in their opening merits brief, they did say that the district court's order is so constrictive to as essentially preclude the same designations for these seals or designations of them altogether because the best available science does not allow for any greater specificity. So it would be in the interest of efficiency to just hear these issues now, and I think the court can rely on what this court did in the Crow Indian tribe case to hear it now.
Are you basically arguing that Alsea is just wrong, though? I mean, it would have been more efficient there, too.
No, I don't think so, Your Honor. I mean, I think this case does fit within the exceptions, and I think a distinction there is that in that case, it was still possible that the agency could still list the fish by reevaluating its distinct population segment and how it was categorizing the fish species at issue in that case, which is a science-based question. It was not a case that had the same statutory interpretations at issue here. And as you sorry,
go ahead.
And and as was noted previously, another distinguishing factor I think is that in the Alsea case, the agency had developed this 4-step action plan that was very detailed in terms of how it was going to comply with the district court's remand, and that there would be a public process. Here, we have none of that.
Does it matter, if I recall correctly, in Alsea, the thing that the lower court had found to be problematic was, or that the decision was in tension with the agency's own rule. And part of what I think we were considering on appeal was that the agency could actually revise its own rule that made its decision inconsistent. So everything was in control, essentially, of the agency. And there's maybe a distinction here because what the district court is saying that the agency's actions were in conflict with was the statute. So in that sense, the agency has no ability to revise the statute. It has to comply with the statute. So to the extent that the district court was saying what you did was inconsistent with the statute, there's really nothing the agency can do on remand to remove the inconsistency other than to change its decision.
Yes.
Is that a fair distinction?
That's correct,
Okay.
Your Honor, yes. Now if I could turn briefly to the merits, assuming your honors get there. In designating the occupied critical habitat for bearded and ringed seals, the agency did everything the Endangered Species Act requires of it. It relied on the best available science to identify the physical and biological features essential to the seals' conservation, and relied on the best available science to identify the specific areas containing these features. And it designated these areas after determining they may require special management and considering the economic and other impacts of the designations. Nothing more was required. And while the designations are no doubt large, that does not render them unlawful. Rather, the size of the designations reflect the huge ranges and life history needs of these ice-dependent seals and the dynamic nature of sea ice, as the agency repeatedly explained in its decisions. And I'd like to start by, discussing the first issue, because that error is one that infected the district court's analysis on the other two issues in our appeal. And specifically, in designating occupied critical habitat, the agency properly designated the specific areas that contain the physical and biological features essential to the conservation of the seals. The district court's holding that the designations are unlawful because the ESA requires the specific areas designated to be essential misreads the ESA and the relevant case law.
Seems like the district court was maybe confused by the Center for Biological Diversity Jaguar case because of the long passage about essential. Can you give us your read of what that was?
Yes, Your Honor. I think if you read that case and the Weyerhaeuser case on which it relies in context, then it becomes clear that both courts were just merely paraphrasing the definition of critical habitat. They weren't holding what the district court read those opinions to hold, nor could they have, because that question was not before either of those courts. And in the Jaguar case, the portions on which the district court relied were about designating unoccupied, which is irrelevant here.
It does seem like dicta, but we have this reasoned dicta rule in our court. Can you tell us why this isn't reasoned dicta, or how you're dealing with that rule?
I think it's unreasoned dicta because it is the standard that applies to unoccupied critical habitat. And here the district court's decision essentially reads out a key phrase from the definition of occupied critical habitat, which is on which are found those physical or biological features. And in the context of the plain language of the statute, essential to the conservation of the species modifies physical and biological features, not the phrase specific areas, such that all the statute requires is that the agency find that the features themselves are essential to the species conservation, which is exactly what the agency did here.
One question I have is that under the language of the ESA, that a critical habitat can't include the entire geographical area. But it would seem to me that your interpretation would actually potentially permit that in every case, so long as the agency says, well, there's this widely dispersed essential feature. So how would your interpretation not collide with the actual statute?
Well, the only geographic limit in the statute itself is that the agency not designate the entire range of the species unless the secretary determines that it's appropriate in that particular case. And here, that's not what happened. They did not designate the entire occupied range of the species. There's, for example, a 30 million acre exclusion in the northern habitat. In the southern habitat, they did not extend the boundaries of the critical habitat as far as the seals occupy those areas because the agency determined those areas don't have the essential sea ice features. They moved the shoreward boundary of the critical habitat between the proposed and final rule after a reevaluation of the best available science to have it be smaller. So this is not a situation where the agency ran afoul of the only restriction in the statute itself. And this court recognized in the polar bear case that, all means all. It doesn't mean nearly all.
Can I ask about, oh, sorry.
Go ahead. No, I had another question, though, about these overlapping areas. In your view, can you isolate in some respect the net benefits to the critical habitat designation that you think are not provided for already?
That was my question, too. The redundancy, can you speak to the redundancy issue?
Right.
The redundancy in the...
Their argument is that these protections would follow from other things without this.
Without that.
I see. So the agency found that there would be numerous benefits to the seals from this critical habitat designation, specifically from the Section 7 consultation process, which would require all federal agencies to ensure that any action they're taking that might affect these habitat areas, to ensure that there wouldn't be any adverse modification or destruction of those habitat areas. The agency also pointed to other benefits to the seals from these critical habitat designations. And
as you read these things you're describing, they're not provided by just the listing of the species.
That's correct. They're not provided for by any other law. It's only the designation of critical habitat that requires agencies to ensure their actions don't adversely modify or destroy that critical habitat. And the agency's analysis on this point is consistent with other information in the record, such as CBD, SER 031-37, which is a study we submitted that finds that species with critical habitat designations are more than twice as likely to be recovering than those without. So the designation of this habitat does provide the species with numerous benefits. And furthermore, the statute requires that the agency designate critical habitat for listed species, irrespective of any other protections that are in place, unless they invoke the rare exception of a not prudency finding, which they did not do here. Unless the court has any other questions, I'll reserve the rest of my time for rebuttal.
Sounds great. Thanks.
Thank you.
Good morning, Your Honors. My name is Norman James. I'm here on behalf of the Applee and Cross Appellant State of Alaska. Let me start. We don't want to wade into the Alsea Valley thicket. We don't have to.
For good reason.
I mean, we view it as a double-edged sword. We did make an agreement, as counsel for the agency said, that if the main appeal is dismissed, we dismiss our cross appeal. That's our position. Okay. So I also wanted to address, though, a related issue, because it actually does segue into the first issue that's been raised here about the failure to properly explain why these enormous critical habitat designations are necessary, because it does tie into the questions that you were asking earlier about Alsea Valley. Reading from the lower court's decision, this is on page star 9, quote, National Marine Fishery Service, NMFS, made these designations, however, without explaining why the entirety of each designated area is necessary to the seal's survival and recovery, or why a smaller area would be inadequate for their conservation, especially since a significant portion of the bearded seal's habitat and most of the ring seal's habitat are outside the United States territory, which is addressed further below. The judge then added a footnote, footnote 101, which I think is relevant to what we're discussing today. Let me find it. At the end of that footnote, the judge said the final sentence, while the court agrees that the designated critical habitats are rather large, the court is not persuaded that an area cannot be essential to the conservation of a species simply because it's large. We don't think that Judge Gleason was trying to create new requirements and impose them on the agency. We think, and there are other places where the judge made similar statements, we think what the judge said was that these are unusually large. That doesn't mean that they're per se invalid, but you have to provide a credible explanation for why you're designating such an enormous area. Again, at the conclusion of her discussion of this issue, she says, because NIMS failed to consider any foreign nation efforts to conserve the seals, and because it failed to articulate a satisfactory explanation for why the entirety of the designated areas in the U.S. territory are indispensable to the seal's survival and recovery, the court finds the service's critical habitat designations for the bearded seal and the ringed seal to be arbitrary and capricious. So we don't read it as precluding the same area from being designated, or for that matter, even a larger area. But the agency has to provide an explanation for why this is critical habitat. And that segues again into the first issue. If you look at critical habitat, you look at the Weyerhaeuser decision, you look at CBD versus the Fish and Wildlife Service decision, which I call the Rosemont case. That was the case. I was actually involved in that case. Those cases dealt generally with what critical habitat is. And in Weyerhaeuser and again in the CBD case, the court reinforced the fact that critical habitat, the term critical, means something. It's critical. It's essential to the conservation of the species. There's a hierarchy in the statute. There's a two-part test, if you will. There's occupied and there's unoccupied. And for many decades, beginning in 1980, when the first regulations were promulgated by the Fish and Wildlife Service and by NIMS, implementing the requirements to designate critical habitat, there was always a requirement that the agency has to show that the designation of the occupied habitat would be insufficient to conserve the species before you could designate unoccupied habitat. That's the, quote, onerous requirement that we've been throwing around. It's a hierarchy. But it doesn't change the fact that it's, as we've discussed in our brief, it's critical habitat. And
I guess I'm confused under your reading how you aren't collapsing occupied and unoccupied. What is the difference between the two if you read occupied to have this additional requirement?
well, in either case, you still have to show that the agency still has to show that there's conservation value to the areas you're designating. The argument being made on the other side.
Yeah, but that's conservation value. Well, I guess it depends what you mean by those words. But this idea that it has to be absolutely essential is not in the statute, as I read it, as for occupied territory. But it seems like you want to add it in, and at that point, it seems like it becomes the same as the unoccupied territory.
Well, but if you do that, Your Honor, you're on the road to getting absurd results. And let me give you a couple of examples that highlight this. In fact, in this case, there were 30 million acres that were excluded from the critical habitat for the ringed seal because the Navy conducts training exercises in that part of the Arctic Ocean. And and remember, when you exclude something under Section 4B2 of the ESA, these are areas that qualify as critical habitat. They meet the test, but you exclude them because of conflicts with economic resource uses, or in this case, national defense. In this case, in excluding 30 million, that's an enormous area. That's the size of Pennsylvania. Okay, so this is not a minor adjustment. The agency said, quote, although the area requested for exclusion contains one or more of the essential features, so it's automatically critical habitat, of the Arctic ringed seal's critical habitat, data are limited at this time to inform our assessment of the relative value of this area to the conservation of the species. So, in other words, you're simply designating areas because of features there, but we don't know whether it's actually going to be helpful to conserve the species. And that's the whole point of critical habitat.
I really don't understand your answer to my question at all. What do you think is the difference between designated occupied territory and designating unoccupied once you add what you want to occupied?
I think there's a higher standard because you start, again, as the hierarchy in the statute, you start with areas that are occupied, and designate those first. Then if those aren't sufficient to conserve the species, you move on and you can designate unoccupied areas. It's a two-part hierarchy.
So I want to go back to your foreign reference, but before I get to that, I want to ask about the exclusions. And it seems to me that the call that the service made was this low marginal benefit of designation, that outweighed the low cost, right? Or low marginal cost. And Alaska doesn't seem to be challenging that, correct?
Well,
and the result was, if you're not really challenging it, what is it, or where is it that the agency's determination is arbitrary and capricious on these exclusions?
Well, I think what the district court found was correct, that the agency determined that critical habitat provides very little benefit because by virtue of the species listing and under the Marine Mammal Protection Act, the species habitat is already being protected. So it doesn't add any real conservation value, any conservation benefit to designate critical habitat. Our argument, and what the judge found below, was that given that the state had requested and North Slope Bureau had requested that areas be excluded, given that the agency found there would be very little benefit to designating critical habitat, it was arbitrary and capricious not to go ahead and at least consider those exclusions. And if you're not going to exclude any areas on the basis of economic impacts, at least give it a fair shake and explain why you're not doing it.
Is your argument a procedural one of a lack of explanation, or is it a substantive one of what the agency was required to do?
I apologize. It really is more procedural, that they just stopped and said, well, we exercise our discretion not to consider it. Mm-hmm. When, again, cases like Bennett versus Speer and Weyerhaeuser tell the service they have to go through the process. They have discretion like any agency as to their ultimate decision, and that's reviewable under the Administrative Procedure Act, but they at least have to go through the process and explain their decision. They didn't do that. They claimed they had discretion to just stop.
But I guess I'm confused about this because, CBD was just arguing that the agency did find benefits, and I even kind of thought at points in your brief you seemed to acknowledge that they had said that. So what is, there's the increased education benefit and awareness of the protected habitat. Why aren't those benefits that the agency identified additional benefits?
Because if you look at the language in the rule, Your Honor, it's all speculation. It's this may happen, this might happen. I could go through and show you. They're all for lack of a better way to put it, sort of the weasel words that you use when, this could happen, this might help.
Is that an issue there with the best available science? A lot of these cases turn on the best, agency is allowed to rely on the best available science, and sometimes the best available science hedges, right? Because scientists can't know things with absolute certainty. So when there's limits to what scientists know, but the agency has to rely on the best available science, it seems to some extent, I think your CBD's position is, the expectation of greater certainty and more justification is just impossible given the limits of science.
Well, the Supreme Court in Bennett versus Speer has said that that term, using the best available science, doesn't allow the agency to speculate. And that's what they're doing. They're not allowed to speculate. You use the best available, and the economic analysis, Your Honor, that we're talking about here is not scientific. There's a big report, and it's frankly a lot of fluff.
But the agency itself has expertise. I guess I'm confused because I thought your initial argument was they just didn't talk about this at all or give an explanation at all. But now you're saying they gave an explanation. It was just too speculative.
Well, they argued, that was in response to your question about the benefits. The primary benefit, and the service even says that over and over in the rule, the primary benefit of designating critical habitat is that area then becomes subject to the adverse modification standard under Section 7. There are these other ancillary benefits that sort of get tossed up there, but the service itself admitted in the rule that that's the primary benefit of designating critical habitat, and we agree. We agree with that. What we don't agree with are sort of larding up the record, if you will, with these other speculative benefits that, again, they're benefits that have nothing to do with designating critical habitat. The purpose of designating critical habitat, again, the touchstone, you're conserving the species. Does it conserve the species? If it doesn't provide a conservation benefit into our cross-claim argument, it's not prudent to designate it. There's no reason to designate it. And that's the case we have here. When the agency is saying there are marginal benefits from designating critical habitat, but we're not going to exclude any areas, it's inconsistent, it's arbitrary, and then to ignore the fact that there is a prudency
there's this
requirement.
confusing aspect of your argument that's saying what they did is just redundant, so it makes no difference, but yet you're here upset about it. So if it's just redundant because everything it requires is already required by something else, why do you care?
Well, we care because, frankly, we think we think that what they're saying is wrong and it's disingenuous.
But who cares if it doesn't cause any effect?
Well, if the agency is doing what it says it's doing, if it's protecting species habitat through consulting under the jeopardy standard, it's not acting consistent with the ESA, and that's what it's saying it's doing. That's not an issue here. I understand your point. Why are you upset if they're saying it doesn't have any effect? The reality is it does have an effect.
Okay, so then it's not redundant. I don't really understand.
Well, but, Your Honor, they're saying it's redundant. I mean, they say it's redundant. They say it's redundant.
If it's redundant, then why do you have standing to challenge this issue? I just don't understand how you can both say you care that there's a problem and the problem is there's nothing happening.
Well, there is something happening because they're misapplying Section 4B2. They're marginalizing the impact of critical habitat, and by doing that, they're avoiding having to take a hard look at whether they should exclude areas from critical habitat. I've seen this happen over and over again.
What is the harm, though, if it makes no practical difference in the world? What is the harm from that?
It does make a difference, Your Honor.
And specifically to the state of Alaska, how?
It does make a difference.
If you're saying the benefits are speculative and redundant.
Because at the same time, they're saying, again, we're not saying this. This is the agency itself saying it. But they also identify, why are we listing critical habitat? What are we trying to protect? What are the threats? The threats are commercial activities along the North Slope. It's oil and gas development. It's commercial transportation. That's why Alaska, we've submitted our comments, that's why Alaska asked to exclude areas from the critical habitat. That's why North Slope Borough did as well. So it does have an impact, we think, but the agency is playing it both ways. They're saying, well, this really doesn't, this does nothing and it has no impact. But if that's true, then it's not prudent to designate it. Why bother? So they're playing it both ways.
Well,
the agency does say that the designation benefits. So, okay.
They really don't. They come up, what they do is they throw a laundry list of speculative things that have nothing to do with the meat of critical habitat, which does it provide a conservation benefit to the species? They say it doesn't because it's already being protected. But then they won't exclude any areas. If it really doesn't matter to the agency, why not exclude the areas that Alaska and North Slope Bureau asked for? I mean, why not just go ahead and say, yeah, this is not really doing anything at all? That's what they said. And again, to loop back to where I started, if you look at the exclusion for the Navy, where you say, well, we're going to exclude this area because we really don't have any information about what the conservation value is. Well, if you don't know what the conservation value is, why are you designating as critical habitat? What other areas in the 160 million acres, likewise, you don't have conservation information on the conservation value? That's the problem. That's what Judge Gleason was getting at with her order. You designate an enormous area. You ignore the fact that there's large populations and significant habitat in other countries, and then turn around and say, well, this really doesn't provide any benefit, but we're not going to exclude any areas either.
let me then turn back to my question about the impact of foreign conservation. So one, I'd like to know generally your view as to whether it's appropriate to consider foreign conservation efforts, and then secondarily to that, whether in fact by determining that a species is threatened, that the foreign impact wouldn't already be subsumed in that determination.
That's a good question. This is frankly a straw man, a red herring. What we argued was this: critical habitat has to be, again, essential to the conservation of the species. That's the touchstone. Now, by rule, you can't designate critical habitat in a foreign country. It's limited to areas within the U.S. jurisdiction. But you can have a situation where there's so much habitat, large populations in a foreign country, that there really isn't any need to be designating critical habitat. In other words, to make that analysis of whether the habitat's essential to the conservation of the species, you have to consider, you can't designate it there, but you have to at least consider it. It's part of the overall calculus. And unfortunately, Judge Gleeson in a couple places used the language, Your Honor, that you referred to about the requirement when you list.
Right.
But there are other requirements in the ESA. For example, there's a requirement in the ESA itself, Section 4, B5B, that requires that when the agency is proposing to designate critical habitat and the species is found in a foreign country, you have to give notice of that to the foreign country. There's also a regulation that the agencies have adopted. It's at 50 CFR 424.13 that requires that notice or requires that the agency consult with the foreign country when they're considering listing or designating critical habitat. Again, not in the foreign country, but if that foreign country contains the species or their citizens hunt the species on the high seas, they have to confer with them. So it's unfortunate that Judge Gleeson used the language she did. Our point was really that...
No, I'm trying to get what your point is.
Yeah.
Thank you.
Yeah, I'm sorry, but the point is that that's part of the calculus. That's part of what you have to consider to know whether the critical habitat is essential to the conservation of the species. Let me give you one other, I'm getting low on time, one quick example. Let me use the jaguar example because take the facts right out of the CBD versus Fish and Wildlife Service case. The jaguar, for example, has an enormous range. It extends from northern Argentina through Brazil, through Central America, through Mexico. It's well over 1 billion acres. It's enormous, and there are large populations in many of these countries. So when you designate critical habitat in southern Arizona, is that critical habitat essential, indispensable to the conservation of the species? No. It's not, because regardless of what happens to the features that you're targeting in that critical habitat, you've got a large population and an enormous amount of habitat next door in Central and South America. If the jaguar is going to recover, that's where the conservation efforts have to take place. Preserving habitat and then restricting uses as a result to protect that habitat, you're not accomplishing anything. There's no real conservation benefit. And that's why you have to consider what's going on in foreign countries.
Okay, we have you over your time. Thank you for your
Thank you,
argument.
I'm sorry.
Let's turn to rebuttal, please.
Thank you, Your Honors. Just a couple of brief points on rebuttal. First, on the foreign conservation efforts issue, the plain language of the Endangered Species Act simply does not require the agency to consider foreign conservation efforts in designating critical habitat. In contrast, it specifies that that is a requirement when listing the species, indicating that that disparate treatment is intentional. And the district court's holding on this issue was inextricably intertwined with its unreasonable determination on the first issue that the agency has to explain why the areas themselves are essential for the conservation of the species, which is the standard for unoccupied habitat, not occupied habitat at issue here. And on the exclusion issue, the district court was wrong on this issue as well. The agency did everything that the Endangered Species Act required of it, and Alaska really points to nothing that the agency failed to consider. It just doesn't like its analysis and ultimate decision, but that is not a reason to overturn the agency's decision, particularly where it did an extensive analysis of the economic cost and the benefit of the designations in, over 100 pages each on each designation. Again, the district court's holding on this point was also intertwined with its erroneous finding on the first issue in the center's appeal. And unless the court has any other questions, I would ask that this court find that it has jurisdiction to hear this appeal, overturn the district court on the 3 issues at issue in the center's appeal, and affirm it on the issue in the cross appeal.
Thank you. Thank you both sides for the helpful arguments. This case is submitted.